Hi everyone, I'm Farizal Farhan. I'm a partner in RDS, leading the energy project and infra practice group for the firm, and I'll be your moderator for today's webinar session. Today with us, we have Nur Syafinaz Vani. Syafinaz is our dispute resolution partner, spearheading our healthcare and medical negligence practices. The topic for today's webinar is medical negligence claims, the significance of expert evidence. As someone who doesn't practice in this area, I can guess that it is important for us to call the experts to give the evidence to support our medical negligence case, like any other negligence case. But the extent of such significance, I'm not so sure. So I leave that to Syafinaz to further explain and elaborate on the topic. Go ahead.
Thank you, Farizal. Thank you everyone for joining us today. Okay, I have like an hour to speak about it. I will pluck out the important issues from the cases, and please feel free to ask questions later on if if you have any. Yep. Just a moment. Okay, the slides are there, right? Okay, in a medical negligence litigation, a medical negligence suit, everyone would know already. A plaintiff sues a medical, sues a doctor, and together at times the hospital, vicarious liability, of course. So to actually prove your claim, for the plaintiff to prove the claim against negligence against the doctors, or vicarious liability on part of the hospital, more so for the doctors, actually, they have, in a way, I would say they have no choice but to call in expert witness to give expert evidence, because these cases are more often than not technical and complicated, which clearly requires an expert that field to come and give evidence. Very rare in medical negligence cases where you need not call expert evidence. Well, there are questions and issues of whether res ipsa loquitur would apply, and you need not, in a way, it's there. You don't have to call an expert to prove it, but it's very, very rare. For example, in a case where probably the doctor left something in your stomach after the surgery, then probably I think that would call for another session to speak on res ipsa in medical negligence claim. Yep, going on to the next one. Of course, in a case where A sues the other party for medical negligence, the plaintiff would of course have their own witness. They would have to have their own witness, and the other side would probably call their own witness to contradict what we say, or obviously have their opposing views. So the problem in medical negligence cases, the issue here is more often than not, we have opposing view. Expert A says this, expert B says this. So going on to the issue that we need to determine in a medical negligence suit, i.e. whether the doctor or medical professional in question that had been sued had performed below a reasonable standard of care, the court has to weigh these two opposing views and come up with a conclusion as to which opinion the court is going to adopt in deciding the case, right? So I will go not so deep. I will go briefly as to the cases, how the cases have evolved from Bola, Bolito, and thereafter. Please ask further questions later, because I would rather answer more questions rather than going through the cases, which I'm sure our participants here would have heard about. Yeah. So the first one, the Bolam's test. This case is, everyone would know. I assume so. It's a doctor's knows best. The test propounded in that case is the doctor knows best test. So basically, the court, okay, an expert is called in to give evidence. Sorry, just a moment. Sorry, there's a slight screen sharing. Just a second. Okay. Okay, sorry, there was a slide sharing issue which I can't seem to make it. Okay, right. Sorry, there it goes. Okay, the first test, the first case that we are talking about is the Bolem's case. So, right, it's a doctor's knows best case. So, you call a witness, Dr. A says this, the court must accept it. It is basically that, right? So, moving on to the next one is the qualified Bolem test. I would say this is the a more logical test to apply, because you see there is it's essentially the test propounded in Bolem, but there is a very important qualification to that test, i.e. that opinion given by that expert must be able to withstand logical analysis. So it's not something where the expert witness says this and the court has to accept this. The court should analyze the evidence given and see whether it is logical, it is acceptable. So basically, the court has a duty to actually value, to actually analyze the opinion given. Right. Okay, basically, the Bolem and Bolem's case as well as Bolito's case, those tests propounded, or of course, has been considered by the Malaysian courts. And the other test, the Australian case, the Rogers and Whittaker, is is another test considered by the Malaysian court. This Rogers test, it actually places the court as the real judge, the real person to actually determine the standard of care, whether it has been breached. It cannot be delegated to the medical expert. This case has been applied in the case. Before this, it has always been, in Malaysia, it has always been Bolem, Bolito. This case was applied in full Fiona. This Rogers test was applied in full Fiona. Of course, when it was applied in full Fiona, it led to a degree of uncertainty in this area. Evolving from there, we have I would say, the celebrated decision, or like that's a case that made it clear as to what test should we apply to determine whether the doctor has breached the standard of care. I'm going through this first so that we can see later how the significance of expert evidence can be brought in with this involvement of cases, right? Okay, so in the case of Hari Krishnan, the federal court aptly drew a distinction between the duty, between the diagnosis and treatment, and the duty to advise the patient of the risk. So there's these two categories here. There are two categories here that we're talking about. So when we are talking about standard of care in relation to diagnosis and treatment, right? The federal court held that this is, of course, not within the expertise of the court, and it cannot be resolved by the court. And hence, the Bolem's test, as qualified in Bolito, would continue to apply, meaning that we have expert evidence, but the expert evidence given must be able to withhold a logical analysis. It is not basically what the doctor say. The court has the duty to analyze it. Moving on to the second category is the duty to advise patient of the risk. This, according to the federal court, is an issue of fact that courts are able to determine. Therefore, the test propounded in Rogers test, the Rogers test as applied in Fiona, would be applicable when determining the standard of care in relation to advising a patient of risk involved in the procedure. Right, so we have two categories here. One, we have Bolito's test, or the qualified Bolem's test, anything you can call it, and the second part of it is the Rogers test, right? moving on to the topic for today. Knowing what is needed to actually determine the breach of standard of care, i.e. or the treatment, diagnosis and treatment, it would be the expert qualified bowler. And for the risk, duty of advising risk, is the Rogers test. We now see how that the expert opinion, significant, how should this be adduced? How does it affect the process of adducing expert evidence in these circumstances? So in essence, with the first category, right, where we are using the qualified Boehm's test to determine the standard of care in relation to the treatment, as mentioned earlier. In essence, it's like I mentioned earlier, it's doctor's knows best test. So the expert opinion given must be capable of withstanding logical analysis. If the expert opinion given is probably rather too general, or it's just it is very rare that an expert opinion by a doctor would not be able to withstand logical analysis unless it is so illogical, very rare. But what I'm trying to say here is it has to be specific, because the role of the expert here is to assist the court. While having the role to assist the court, the person giving the opinion must make sure that their opinion would logically help the court, you see. So I would say that with this evolvement to this case of Bolito, the expert plays a bigger role in aspect of giving expert opinion. It is not a matter of you coming to court and saying something and the court will accept it. If let's say I'm the plaintiff and I call an expert witness to come to court and give evidence, I can't be just certain that the court will accept it because of this logical analysis test. So who am I calling to? The person who I am calling to give evidence must know the area very, very well. Bear in mind, he's going to be cross-examined, right? Of course. So in that regard, right, the cases propounded and the evolvement of the case from just Bolito and everything. Sorry, this slide is just like moving. It is very important for the doctor who is called as expert to be very familiar and very well versed with the medical field in question. For example, if you're having an issue of somebody who, let's say, went through surgery for removal of ovary, operectomy or something of that sort, it is very, very important for you to call someone who is the expert, who is very, very well versed, familiar in that field, because the medical standards required for that particular procedure, for that particular surgery, the expert must be very, very well versed, because it is not a matter of just giving an expert opinion, which is not confined to that area that you're giving. What I'm trying to say here is it is more like calling a quality expert opinion. I have had cases where professional negligence, right? But I'm just moving away a bit from medical negligence here. But the person who is called to give evidence is basically giving general evidence, like, yeah, a doctor should do this, not a doctor, a person should do this before this procedure is taken. No, it cannot be that way. For example, in a surgery for operectomy, a surgery to remove ovary, you have a different set of standard that the doctor should adhere to in that kind of surgery. You can't be calling a general surgeon to give an opinion. We have had that. And of course, if you have a plaintiff calling this expert witness who is not quite familiar and not the person for that area, and other side calls a familiar and very well-versed medical expert in that field, weighing the witnesses, the evidence given, the opinion given, the court would obviously, which one would withhold logical analysis? Obviously, the other one, which came from a very familiar person, which came from a person who's very familiar and well versed with the medical field in question, right? And one more thing in medical negligence claim, right? With this, I would say a more onerous duty, not to say onerous, okay, I'll just, a more stringent duty for doctors in giving, for medical professionals in giving expert opinion. The very important thing that you should bear in mind is it cannot be a position where I'm just putting myself as the witness. I cannot come to court in a view to protect my peers in the profession without cogent justification. I'm not saying you shouldn't protect, but when a doctor is coming, you should have justification. Testimonies cannot be given defensively just to protect your peers in the profession. If it is wrong and logically it is wrong, it has to be said that perhaps this is not the procedure, this is not the treatment, the diagnosis that should be given, and such risk, this particular risk should have been advised. Like if there could be a risk of, for example, a 20-year-old girl going for a surgery, obviously, I mean, not obviously for going for a surgery, if there is a risk of the need of removal of both ovary. I'm using this example because it's something familiar to me. If there is a risk that you need to remove both ovary fully, rather than just removing from, for example, the cyst, it would be logical that you should advise the person who is going to surgery. So bearing in mind what I mentioned earlier, that the person has to be familiar, has to be well versed with the medical field. He has to also give logical opinion that, in that circumstances, you'll be expected to advise, or you'll be expected to take this step in that procedure. Okay, protecting peers is one thing. Giving impartial evidence in court is one thing. It is important that doctors who are called, they have a duty towards the court. They don't have a duty towards the plaintiff who's calling. Let's say I'm the plaintiff, there's a witness coming. No duty to me. It's a duty to court, and more so, you should act fairly and impartially. You cannot be protecting one side or another. Okay. Okay, but let me just go back to the part where I say, the duty of to advise risk, and a duty to actually. The first one is duty for treatment, the treatment, and the other one is to advise risk. I think the more uncertain area is to advise risk, because many times it can be said that, many times it can be said that, in the normal circumstances, we would not advise that this is a risk. And well, when I went when I had a procedure, I don't have, very rare that the doctors come and sit next to you and explain for an hour as to what risk you're taking. It's just a very, very brief explanation. I think this should be something that must be, kept in mind. While it is an accepted practice that the risk is advised to a certain extent, but while giving evidence in court, because there was a case, one matter where a question was put as to whether this way of giving, basically the doctor came to the bedside and said, look, okay, this is a surgery I'm going to perform, so there's a risk that this might happen. Okay, right, that's it. So the question put to the plaintiff's expert witness is that, is this the accepted way of just, informing the risk? Nothing further, just that. So the doctor actually said, yes, it's all right for you to just say it, and then, just say, okay, that's a risk. And the patient says yes, and that's it, you have advised, you are done. The standard of care for you to advise the risk is there. And the other side actually called another, the other side called a foreign medical expert simply because they could not get a local doctor to actually give evidence. It is tough, like I mentioned earlier. There is of course, it's difficult for a doctor to come and give evidence against your peers. Like, similarly for lawyers, it's tough for you to go and say, look, the person has done something so wrong or whatever. So the expert opinion, expert witness for the other side was, overseas doctor. He came, he said, no, this is not. So the whole issue there, I'm trying to just delve with the expert thing, because generally expert witness based on the case, it's just that you need to be very well versed in your field. But the whole point is, when you have difficulty to actually, determine, like I said earlier, this doctor said, yeah, it's all right. You cannot get someone from the country to say, no, it's not. We got someone else from Australia. The court actually accepted evidence from the other side, which says that they should, the standard should be, some further things should be mentioned in that particular procedure. It was a prostrate issue. So you have to mention further risk of what that could happen. So basically, while there is no specific standard, the standard, I would comfortably say it depends, of course, on a case-to-case basis. It depends on the expert witness that is given, expert witness that comes to give evidence for you. For example, on the plaintiff side, if I'm acting for the plaintiff, this is the most important factor, because if your expert witness cannot withstand the cross-examination and is there to just give evidence, he has to bear in mind that while he's giving evidence for you, you have someone on the other side who's giving evidence for the other side. So for expert witness on your side, he has to first thing be certain with what he has to say. What issues that I have seen so far is that the tendency to want to say this and this and this, but there is no justification to it. It is basically, my view is this, and that's it. No justification, nothing. Whereas the other side of the expert witness, if you're acting doctor, they have a very, in the case I did, it was a very proper and justified expert opinion as to why, if this is not done, then what should have been done. So basically, coming to a very brief conclusion on this, it has to be cogent, justified, obviously logical, just because the case say it has to withstand logical analysis. But if your opinion, if your expert has an opinion which is cogent, justified, then I would say that, I mean, the courts would most probably accept your side, the expert opinion. The problem comes when we're talking about cogent, justified. If you're just calling in general experts, the issue that I've seen so far is the expert call is not quite an expert in that field. If you're having a medical negligence claim, you cannot just call a doctor. You have to call probably a specialist in that area. Some, not all, yeah, some I've seen, they've just called general. So how are you going to justify, with cogent explanation, when things are put to you for that particular area, a very, very specific particular area of procedure or surgery or disease? How are you going to justify? They could, but they might not. So that would actually be fatal to the claim, whichever side you are on, whichever side you are on, whether you're the plaintiff or the defendant. So yeah, basically, right, I would rather take more questions on this. So my conclusion on this expert witness is the need for you to carefully choose your expert witness. And it is very, very, very important for the witness to be a specialist and to be a very well-versed person in that area that you're suing upon, or that you are being sued upon. Please ask more questions on this, because I think that's the best way for me to explain if there's any query. Farizal, you have anything to ask?
Okay. Okay, thank you, Syafinaz, for that sweet and concise presentation. For those who have any questions, please feel free to submit them by pressing the Q&A button right at the bottom of your Zoom panel there. And Syafinaz will do her best to answer your questions. While we wait for that, can I summarize that, number one, expert evidence is very important in the case of medical negligence for both sides, plaintiff and defendant. Number two, the expert must be a real expert. It can't be, somebody who's generally a GP, for example. It must be somebody who has either specific education or real life experience in the area. Number three, the expert must be able to justify and give reasons for his or her expert opinion to court. Otherwise, uh, your what do you call that evidence will not carry weight in court. Is that? If you have anything to add, if there's any takeaway to that, those are the three things that I get from your presentation.
Yeah, that's right, Farizal, a very brief one. So, yeah.
So we've got a few questions. Number one,
Where is
this
the,
is from Mr.
I
Abid.
see the questions. Sorry, Farizal, how do I see the questions?
No, I'll read it to you.
Okay. Thank you.
Seek expert opinion before or after the commencement of the suit?
Okay, should we seek expert opinion before or after? It has to be, in my, I think it has to be, in my view, it has to be before, because you are planning your strategy, the case. For example, maybe what the question meant was before you file the suit.
File an action.
Yeah. We have had clients coming to us in anticipation of suing. Okay, my previous experience is it's very difficult when you're acting for the plaintiff to find an expert to come and say that, yeah, that is wrong. It is different if I'm acting for the doctor. It is easier. I feel so. I mean, I've not had so much of difficulty. So if in a case where the plaintiff approaches me, well, after they retain us, of course, we would source for medical expert before we commence the suit. And of course, at times we won't get a definite one before we actually file the suit. Yeah, but the best, I think, if you're acting for the plaintiff, try source before you file the suit, because you would have the details with you already, with the process of disclosure and all that. Before that it would have to be addressed in a different webinar where you get disclosure, you get the medical records and everything. So when you have that already, I think you can start sourcing for medical expert, because like I said earlier, there's a case where we had to go, the other side's expert from Australia, so they had to push the trial quite a number of times because they had to call expert. And of course, we were very cooperative in that sense because, they cannot get one from here. So had that been planned earlier, perhaps, it would also expedite matters, because we are looking at interests of both sides. We don't want to be delaying and getting witness in. And bear in mind now with the pre-trial directions, it is all very fast. So you need to put in your documents and all quite early. Yeah. So it has to be, ideally it should be before, or since you start before.
Okay, there's another question. Would a complaint on any medical negligence cases against doctors made to the medical council before commencing the suit be helpful to assist the plaintiff's case?
Oh, okay. MMC, right?
Yeah.
Actually, right, there is this. Okay, there was a issue last time. Matters referred to or complained to MMC were not attended to, and only a few is attended to. But what we have to bear in mind is MMC, they do not actually deal with medical negligence per se, unless it involves some ethical violation. Right. So I think when that issue was brought up, it was a situation where people are saying that, some cases we complain to MMC, no steps are taken. Basically, if you have issues against, for example, right, a doctor refuses to see you, and it's something related to ethical issues, not so much about, I went for this procedure, you should not have done this, he's negligent. That one you have commence court suit. So to that question, if it involves some ethical violation, yes, it's open for you to go to MMC, and they have their procedures, all the disciplinary hearings and so on and so forth. But on the aspect of medical negligence, claiming for damages and those things, it has to be through a court. It is not, I mean, if I get the question right, it is not a standard operating procedure or a procedure where you go to the
Not
MMC
prerequisite
first.
lah.
No, correct. That's the word. Thanks, Farizal. Not a prerequisite that you go to MMC first and then you complain, then you file a suit. No. Yeah.
Okay, we have another one. I think this
Sorry,
is
Farizal. Just on that, right? Sorry, I'm
yeah,
sorry.
go ahead.
Just on that. I think the ethical part, right? The ethical part, yes, MMC. But this negligence part, of course, before you commence the suit, usually there's a disclosure proceedings taken for you to get the medical records and all. So on that part also, you see, to commence a medical negligence claim, this is what you do, the medical reports and everything. So probably there, when let's say I ask for medical report and they refuse to give unnecessarily, and that part would of course go to the, it would breach some of the regulations, I suppose, because you have to keep it for a certain number of years, or a certain number of time if the matter is actually litigated, on that point. Thanks, Farizal.
In deciding between whether between one procedure or the other, in deciding between the two, you don't think that it should be brought to the MMC?
Only if, because MMC, they're not bound to actually deal with medical negligence claim. It's just ethical issues. Like for example, right, I think even I don't know whether I should compare it to lawyers, but I think we have our DB, right, disciplinary board, that deals with all those complaints, but still for professional negligence claim, we still file it in court if you have suffered damages and things like that, right? We still sue in court. But for doctors, my understanding, ethical stuff, yes, you can go to MMC. If medical negligence, I don't think MMC has no, maybe it's too fast. They have no duty to actually deal with medical negligence allegations, claims, and so on.
Okay. What about the timing to bring an action? How long do you have?
Limitation if 6 years, right? But if of course it's a dependency claim and it's 3 years, so it depends. It's very fact centric. It's very fact centric. Depends whether it's 6 or 3, and also depends on the course of action accrued.
Okay. I think we've got no more questions left.
Unless Farizal got more questions.
I think I've got none. With that, I think we should end. So thank you, Syafinaz, for a very concise and quick presentation. And thank you to the participants who attended. And I hope to see you guys in our next session soon.
Yeah, we can have a longer session so the matter can be, we can have another topic soon, probably on disclosure or something. Okay, thank you for joining.
Thank you, everyone. Bye.